Welcome back to The Legal Take, where we break down the law behind today's biggest headlines with clarity, context, and zero jargon. I'm your host, Andrea, and today we need to talk about a case that could fundamentally reshape drug policy in the United States. A group of major cannabis companies have filed a lawsuit arguing that the federal government's prohibition of marijuana under the Controlled Substances Act is unconstitutional. If this case reaches the U.S. Supreme Court, it could trigger one of the most consequential rulings on federal power, states' rights, commerce, and drug regulation in decades. We're going to break it all down. What this lawsuit actually argues, why it's gaining serious traction, why some experts strongly oppose ending the federal ban, what a Supreme Court showdown might look like, and how this could rewrite federal drug law nationwide. So let's dive in. Cannabis occupies one of the strangest legal positions in America. At the federal level, under the Controlled Substances Act, marijuana is a Schedule I drug, classified alongside heroin, LSD, and MDMA. According to federal law, marijuana has a high potential for abuse, no accepted medical use, and no accepted safety profile. But then you zoom out to the states, and the picture is completely different. 24 states have legalized adult-use recreational cannabis. 38 states allow medical cannabis. And now, the cannabis industry is a multi-billion-dollar legal marketplace. Yet technically, every grower, retailer, and user in the country is committing a federal crime. And for decades, the federal government has tolerated, but never fully blessed, state legal cannabis industries. This dissonance is the backdrop for the lawsuit we're discussing today. Back in late 2023, a group of cannabis businesses, including growers, sellers, and processors, filed suit against the federal government. They argue that applying the federal ban on marijuana, even within states that have legalized it, oversteps Congress's constitutional powers under the Commerce Clause and violates due process. The plaintiffs include multi-state operators and state legal businesses who claim the prohibition harms their livelihood, prevents normal banking and financial operations, restricts property use, and blocks access to credit and insurance. Their core argument is this: Congress does not have the authority under the Commerce Clause to criminalize purely intrastate cannabis activity that is legal under state law. Specifically, the plaintiffs argue the cannabis industry is now overwhelmingly intrastate. A dispensary growing and selling cannabis within Colorado, under Colorado law, isn't engaging in interstate commerce at all. Congress's original justification for banning marijuana no longer makes sense. When the Controlled Substances Act was passed in 1970, no state allowed cannabis. Today, most do. The federal ban imposes unconstitutional burdens, including extreme tax penalties under IRS Code Section 280E, lack of access to banking, inability to transport products between legal states, and the constant risk of federal enforcement. The next argument is that the legal world has shifted since Gonzales versus Raich. In Raich, the Supreme Court upheld the federal ban based on fears that state-level cannabis would spill into interstate markets. Plaintiffs argue that today's regulated state programs, with seed-to-sale tracking, eliminate that concern. In short, the plaintiffs want the courts to rule that the federal ban cannot apply to state-regulated cannabis. In July 2024, a federal district court in Massachusetts dismissed the case. The judge relied on long-standing precedent that gives Congress wide latitude to regulate controlled substances. Specifically, the court leaned on the 2005 decision Gonzales versus Raich, where the Supreme Court ruled state laws permitting the medical use of marijuana do not prevent Congress from prohibiting its use for any purpose in those states under the Commerce Clause. But the fight didn't end there. The plaintiffs appealed, and now they've asked the Supreme Court to review the case. As of late 2025, the court has extended the deadline for the government's response, signaling that they're taking the petition seriously. That means this dispute could arrive before the highest court. And if SCOTUS agrees to hear it, it could become the most significant ruling on federal drug law in the United States. Let's break down the plaintiffs' constitutional claims. The first issue is Commerce Clause overreach. The Commerce Clause is a U.S. constitutional provision under Article 1, Section 8 that grants Congress the power to regulate commerce with foreign nations and among the several states and with Indian tribes. This serves as a major source for federal economic law, allowing Congress to control activities crossing state lines and preventing states from creating trade barriers, ensuring a unified national economy. The plaintiffs argue the feds can regulate interstate commerce, but not activity confined within a single state. Plaintiffs say the CSA's blanket prohibition exceeds that power. The next issue is equal protection and rational basis. The rational basis test is the lowest standard courts can use to check if a law violating equal protection is constitutional. The law must be rationally or reasonably related to a legitimate government goal, a relatively easy bar for laws to clear unless they target suspect groups or fundamental rights. Plaintiffs argue that there is no rational basis for treating marijuana as more dangerous than alcohol or tobacco, both of which are federally regulated and not prohibited. The third issue is due process. Substantive due process is a limit on the government's power to enact laws or regulations that affect one's life, liberty, or property rights. The CSA may violate principles of fairness and consistency, given the drastic shifts in public policy and medical evidence. And the last issue is anti-commandeering principles. States have the right to legalize cannabis without federal interference. These arguments have generated major attention, but they are only half the story, because there are also powerful arguments against removing the federal ban, which brings us to our next section. Not everyone agrees that ending federal marijuana prohibition is a good idea. And to understand the full legal landscape, we need to look at the arguments from the other side, from law enforcement agencies, health policy experts, some members of Congress, and even federal courts. Let's review the major arguments. Argument number 1. Congress does have authority under the Commerce Clause. Opponents say even purely intrastate cannabis has substantial economic effects on the national market, which is enough for Congress to regulate it. This is rooted directly in Gonzales versus Raich, where the Supreme Court held that Congress can ban even small-scale, state-legal cannabis activity if it forms part of a broader regulatory scheme. This precedent is still binding. Argument number 2. Removing the federal ban could create chaos, not clarity. Federal prohibition provides a uniform national framework. If the federal ban disappears without replacement regulations, every state's rules could clash, interstate commerce could become a legal free-for-all, states with strict rules could be flooded with products from states with weaker controls, national consumer safety standards wouldn't exist, and a patchwork of 50 different cannabis markets could create major public health challenges. Opponents argue the proper path is congressional reform, not court-ordered deregulation. Argument number 3. Cannabis still has abuse and public health risks. Some public health groups argue that legalization has led to increases in high-potency THC usage, pediatric exposures, cannabis-impaired driving, and increases in addiction and dependency rates. They argue that removing federal oversight could impede national research, health monitoring, and consistent labeling standards. Argument number 4. This could limit Congress's power for future public health crises. A ruling limiting Congress's Commerce Clause authority could affect drug regulation, environmental laws, workplace safety, and food and pharmaceutical oversight. Opponents fear this case could unintentionally strengthen federal power across the board. Argument number 5. Courts should not override Congress. Some judges take the position, even if federal prohibition is outdated, this is a policy-making issue, not a constitutional one. In other words, if the law needs changing, Congress, not the courts, should change it. These arguments don't necessarily win, but they show why this lawsuit is far from a guaranteed victory. And they set the stage for the next big question. What happens if the plaintiffs win? Or if they lose? A win for the cannabis companies would be revolutionary. Federal prohibition would no longer apply to state legal cannabis. States would decide, and the feds would have to step back. Interstate commerce could explode overnight. Oregon could ship the flower to New York. California could sell edibles to Illinois, and prices would drop dramatically. IRS Code Section 280E would disappear. Cannabis companies could deduct normal business expenses for the first time ever. Banking barriers would fall. Credit cards, loans, payroll systems would all be available to cannabis-related businesses. The FDA may step in, especially with edibles and concentrates. And rapid consolidation. Big players, alcohol, tobacco, pharma, could enter the market instantly. This would be the single greatest shift in cannabis law since the first state legalization in 2012. If the government wins, especially with a strong Supreme Court endorsement, Raich would remain the law of the land. The feds would retain broad power to regulate cannabis, even inside a single state. The federal-state conflict would continue unchanged. States legalize, feds tolerate, and everyone functions in a gray zone. Congress becomes the only path to reform. Cases like this close the judicial door. Cannabis companies continue facing Section 280E tax penalties, cash-based operations, banking risks, and no interstate commerce. Markets would stay fractured. California can't sell to Nevada, Massachusetts can't sell to New Jersey. A win for the government would preserve the status quo. The Supreme Court takes fewer than 1% of petitions, so the bar is high. But this case actually has several features SCOTUS likes. A clean constitutional question in whether the Controlled Substances Act exceeds Congress's authority. National importance. There are huge economic and regulatory implications. Division among states. With legalization spreading, national conflict is intensifying. A chance to revisit an old precedent. Many current justices weren't on the court when Raich was decided. And clear stakes. The court loves bright line outcomes. Whether they will take it is hard to predict, but the odds are higher than usual. So how might today's court analyze this case? The conservative majority have generally favored limiting federal regulatory power, as evidenced in recent EPA cases, OSHA cases, and vaccine mandates. Some justices have already questioned Raich in past writings. The liberal wing is typically more deferential to Congress's commerce powers. Some possible outcomes include a narrow win for the plaintiffs, where states regulate cannabis and the feds can't interfere. A narrow win for the government, reaffirming Raich. A broad ruling restructuring federal power. This is possible, but less likely. And avoiding the issue entirely by dismissing on procedural grounds. Any of these outcomes would be seismic. This case is one to watch. If courts say federal marijuana prohibition is unconstitutional, it could unlock interstate commerce, reshape national drug policy, and expand the rights of states to chart their own course. If courts uphold the federal ban, then the ball is placed firmly in Congress's court, and the pressure to act will only grow. Either way, the stakes are massive. Thank you for watching The Legal Take, where we break down the law behind the headlines. If you learned something today, don't forget to subscribe, leave a comment, and share this episode. And as always, I'm Andrea, and this has been your Legal Take. Until next time, stay informed, stay curious, and stay legally minded.